Bismillahirrahmanirrahim. Sources of international law. Up to this lecture, we had discussed 5 sources of international law. In a short recap, there are, according to the writers, according to jurists, according to international law experts, there are 2 types of sources of international law: formal sources and material sources. And the statutes of International Court of Justice also provides a clue and a directory order for application of sources of international law. And in this lecture, we shall discuss the 5th source of international law, that is decisions and determinations of the organs of international institutions or international conferences. Organs of international institutions mean the international institutes like UNO, like European Union, and their organs like a Security Council, like a General Assembly, Labour Organization, Food Development Organization. All these are the organs of international institutions, and their decisions and determinations in a certain cases, in a certain observations, in a certain precedents also provide sources of international law and rules for the international procedures, etc. And decisions relating to questions of jurisdiction of the organs of international institutions may lead to formation of rules of international law. The decisions or determinations of the organs of international institutions or international conferences may have law-making effect as a source of international law in a number of different ways. It means they are not a directly and a direct source of international law. They become a source of international law in a different ways, and few of them are as such. Number one, they may be intermediate or final steps in the evolution of customary rules, especially those regulating the constitutional functioning of these institutions. The final criterion is the extent to which the decisions, determination or recommendation has been adhered to in practice of itself is not a normative effect. The second one is a resolution of the organ of an international institution which validly frames the regulation or principle for internal working of the institution may have full-fledged legal effect. The third one, the decisions regarding determination of questions of jurisdiction in absence of explicit provisions of international law. Such decisions by its own questions of jurisdiction may have law-making effect. Third one, the interpretations of their constituent instruments by organs international institutions. Fifth one, the empowerment of certain organs of international institutions to give general decisions or directives or causal legislative effect binding on all the members. Fifth one, opinions of committees of jurists constituted by organs of international institutions to investigate a legal problem. The sixth one is important. When the organs of international institutions appoints a committee of experts, of jurists of international law, and they give opinion or observance or a recommendation, that also become a source of international law in an indirect way. The sixth source of international law is general principle law recognized by civilized nation. Here means general principle means the principle accepted by generality, public at large, societies at large, countries at large, and civilized nation means the nation that has evolved and developed and have a acceptable attitude in the framework of international law. The general principle of law recognized by civilized nations are also the vital source of international law. Notable general principles recognized by International Court of Justice are as follows. It means these principles of common law, state law, also adopted by the International Court of Justice (ICJ), and they become a source of international law. First one is like state law, the principle of res judicata, the principle of estoppel, ade alteram partem, which means nobody should be condemned unheard, prescription, the responsibility, good faith, a party to case can't be judge or an arbiter to his own cause, which in a common law or state law is applied as a no one should be judged in his own cause. Nemo judex causa sua. These are the principle of law, general law, recognized by civilized nations that are also the source of international law. The seventh source of international law is the state papers. State papers mean the state paper excluding the treaties are also another source of international law. Here one thing is very important. Treaties are also the state paper. The states which are entered are those who have entered upon into treaties. They are also called the state paper, but the treaties are direct source of international law. They have law-making authority. But here in the other state papers which are not which included not treaties, they are also source of international law. The records of Foreign Affairs Department of all the states contain the reasonable volume of experts' opinion, which may also lead to formation of international law. And one other important principle, which is just cogence, preemptory principle, norms of international law. Just cogence means where there is no principle of law available, no rule of law available, no precedent, no treaty, no other, then when a matter is brought before a court, ICJ, arbiter or other form, that then the in a common law like a equity principle, the principle of just cogence. Just cogence means the to decide a case in a fair manner, in a judicious manner, that is called the just cogence. It is also the principle which is applicable in international law and a source of international law. The secondary sources of international law, sometimes the examiner asked also short question or a question part of a sources of international as a secondary sources of international law. And these are the Roman law. Roman law also provides principle of international law. Islamic law, Islamic jurisprudence have also principles of international law like appointment of diplomats, regulation of wars, and the duties and rights of the diplomats, state representatives, that are also regulated by Roman law as well as Islamic law. Principles of equity and justice also source of international law. State practices, private contracts, principles set by international community, judicial decisions of state courts, and at the last, just cogence. As we have already discussed, just cogence is also source of international law. And at the end, we conclude the whole topic with the conclusion that the sources of international law are not like a sources of state law where the parliament or a congress or some other body act as a legislature and provide sources and provide rules, laws, regulations. But here in case of international law, there are different 8 to 9 sources of international law like customs, treaties, judicial decisions, determination and decisions of the organs of international institutes, precedents, etc. And there are 2 types of sources, formal and the other one is material. And paragraph 1 of Article 38 of Statutes of International Court of Justice (ICJ) also provides order for applicability of sources of international law in case of some issue put before ICJ. Thank you very much.